This is the face of a man who wants to take on the Internal Revenue Service. This is Wiley S. Drake, a pastor of the First Southern Baptist Church in Buena Park, California, and he doesn't like one of the IRS rules, and therefore he is going to challenge it. Welcome, everybody. This is Stephen Haas for the National Paralegal College Faculty's Legal Analysis of the News. And today what I wanted to discuss, and today, by the way, it is September the 26th of the year 2008, what I did want to discuss is an interesting case that I saw on the news the other day about a group of pastors who want to challenge the IRS regulation that prohibits tax-exempt organizations, tax-exempt religious organizations, from taking political stances with regard to political candidates. Or I shouldn't say it prohibits it, but it says if you do that, you are going to lose your tax-exempt status. And many pastors and religious organizations do not like this. And so therefore, as you can see from this article in the Los Angeles Times, there are some pastors who plan to defy the IRS ban on political speech. They are planning to go to the pulpits very specifically, this coming Sunday, and to deliver political sermons or endorse political candidates to defy a federal ban on campaigning for not-for-profit groups. And not only that, they're hoping that the IRS will investigate. They're trying to trigger IRS investigations. Why? Because this would allow their patron, the conservative legal group Alliance Defense Fund, to challenge the IRS rules. What they're trying to do over here, Reverend Drake, you can see a quote over here, he agrees that he thinks that people should not vote for Senator Obama because it's against his religion or whatever it is. And so in essence, they don't like this idea that says that political groups cannot, religious groups and churches cannot endorse or go against any individual political candidate. Another thing I noticed about the story, as I just mentioned, is that they're not just challenging the law outright. They're not bringing lawsuits initially. What they first want to do is they first need people to go ahead and actually violate the law and get cracked down on by the IRS in order to actually challenge the law in court. As you can see, they are actively recruiting pastors to challenge the so-called Johnson Law, which is the one that prohibits religious organizations that have tax-exempt status under the IRS from espousing or supporting a political candidate or basically getting too heavily involved into politics. And they're saying if this triggers an IRS investigation, then the Arizona-based legal group will sue to overturn the federal rules which were enacted back in 1954. And in fact, the story of how they were enacted in history is a little bit beyond the scope of what I want to discuss, but if you want to Google that, it really is a fascinating history that goes back to several rules enacted over the course of several decades. They claim, the Alliance Defense Fund, the organization that's trying to start this brouhaha, said that the regulations amount to an unconstitutional limit on free speech and government intrusion into religion. And as I said, it certainly has a chilling effect, and that there's a lot of fear and intimidation and disinformation about the parameters that do exist. So there are really two issues that I want to discuss. The first issue is the question, the really procedural question, is why do they have to go ahead and get these pastors to be investigated, get these pastors to violate federal tax law before they can challenge it in court? Why can't they just challenge it right now? Why do they have to get the IRS to investigate and try to remove some tax-exempt status from these organizations? And second of all, what will happen on the merits? Is there any precedent? Is there any history that we can look to determine what the courts might do in this kind of a scenario? Okay, so let's look at the first question first. And to discuss the first question, why these pastors have to go ahead and try to violate federal law before they can challenge it, we really have to look back at the U.S. Constitution. Now, of course, the U.S. Constitution applies and sets up the federal courts and how the federal courts operate. Now, if you look over here, which is Article 3 of the U.S. Constitution, which deals with the courts, the judiciary branch of the government, Section 2 discusses the authority of the federal courts and what they can hear. As you can see, the judicial power shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, etc. And then it also says all cases involving ambassadors, all cases involving admiralty, to controversies which the United States shall be a party, to controversies between two or more states, etc. If you look at this article, everything that the judicial authority has the authority to hear is either referred to by the Constitution as a case or a controversy. And that has led to the quote-unquote cases or controversies doctrine that the Supreme Court has enacted based on the Constitution. And that is that in order for a federal court to hear a case, to have a case come before it, it has to be a case or controversy. That means it can't be speculative, the parties can't be there wanting to know something. They can't ask, have the court say, well, gee, I want to know what the law is, let's go to court and find out. That's not the job of courts. Courts only handle cases that only handle issues that are cases or controversies between parties who actually have a stake in the matter. For example, if a case is moot, if a case is no longer relevant, if the law that you're challenging has been repealed already, if the law has never been enforced against you, if the case is not ripe, these things have been held by the courts, especially by the Supreme Court, to not be within the scope of the federal courts to handle. And one of those rules, one of the sub-rules, the corollaries to the case or controversy rule, is the doctrine of standing. Now, what standing means, in order to sue, you have to have standing to challenge a particular law. It has to affect you. It has to be something that is going to hurt you unless you challenge it successfully. You have to allege a legally cognizable injury, is what the courts have said. The courts have to be able to recognize the injury that you're threatened with or that you did suffer in order for you to bring a case in court. Just because you disagree with the law, it does not inherently give you the right to bring a case. For example, a very famous 1984 case, a case called Allen versus Wright, a group of minority students, a group of black students and their parents, had brought an action against certain discriminatory schools, against schools that did not allow black children in. And they said that the IRS should not allow a tax-exempt status for these private schools. Private schools can basically do whatever they want. They can allow anybody they want. But what the parents said, what the plaintiff said, is that they should not be afforded tax-exempt status because, in essence, you are perpetuating and allowing these people to continue discriminating on the basis of race. So the IRS should not be able to allow these people to continue to get tax-exempt status. Well, the Supreme Court said you don't have any standing to challenge that. If you look at what the Supreme Court said over here, the first basis for standing alleged is that they were harmed directly by the mere fact that government financial aid to discriminatory private schools did, and the court said that the fact that the financial aid goes to discriminatory private schools does not constitute a judicially cognizable injury. And their other claim, that the children were being deprived of the opportunity to receive an education in racially integrated schools. In other words, the idea that because these private schools are discriminating and only allowing white children into these schools, it's now making the other schools less integrated, because all these white children who would ordinarily be integrating the rest of the schools are now being drawn away by these private schools that don't allow anybody else in, and so therefore we're suffering an injury. Well, the Supreme Court disagreed. The Supreme Court said that is not fairly traceable to the government conduct that the respondents challenged as unlawful. So you can see, in other words, the idea is, if they would have applied and been rejected to this private school, that might have been a different issue. The Supreme Court might have allowed that case to go forward. But just the fact that there is discrimination going on in your town or in your system, unless you can show a legally cognizable injury, you're not even going to be able to get into the front door of the court. In fact, this issue has also been applied to a much more similar case to ours. In a later case, actually, that happened last year, Hine versus Freedom from Religion Foundation. This challenged President Bush's faith-based initiatives. For those of you who may not be familiar, President Bush, when he first came in and really throughout his presidency, has been, espoused the idea that certain federal programs should fund religious organizations to do secular work. For example, a church running a drug rehab or something to that effect. They call it a faith-based initiative because their secular goals, getting people off of drugs or, relieving people from poverty, but they're achieved through religious organizations and sometimes through religious uses and religious activities. And so this was challenged. Some of these faith-based initiative programs were challenged by a group, among others. It was challenged, I think, at one point by the ACLU, but in this case, it was being challenged by an organization called the Freedom from Religion Foundation. And they claimed that this was preferring religion. This violates the Establishment Clause of the Constitution, which prohibits the government of the United States from establishing religion. In this case, they're alleging that they're preferring religious groups over other groups by giving them funding. And the Supreme Court said that you have no standing to bring this case, even though respondents